Of energy companies today because oil prices rose, and this week's Federal Reserve meeting expected to report a third interest rate hike this year. That meeting starts tomorrow, decision on Wednesday. Apple was a big gainer today after confirming it's buying the app Shazam. It helps listeners identify songs they don't know, and also there are reports it's getting iPhone Xs to stores more quickly. Verizon extending its streaming deal with the NFL another 5 years to watch games on your phone or on Yahoo or AOL. CNBC.
Sarah, can you step in here a moment?
Sure.
So, big news?
Oh?
You're being promoted to regional sales manager.
That's great to hear, Alan. Thank you.
Talk to corporate. Approve memo.
Tens of millions of songs, one for every moment. Amazon Music Unlimited. For a limited time only, sign up today and receive 3 months for 99 cents at amazon.com/music unlimited. Automatically renews, cancel anytime.
Sarah, you can leave now.
Okay.
Colonel Sanders here with another important holiday message from KFC. This year, don't get the ones you love some lame, boring gift like a new car, or jewelry, or toys, or expensive electronics, or any other junk. Nope, get that special someone what they really want. Exactly! A KFC $5 fill-up with 100% white meat popcorn chicken, mashed potatoes and gravy, a biscuit, a cookie, and a drink. It's a perfect gift for all those important people in your life who get hungry right around lunchtime. KFC, it's finger-licking good. Available for a limited time only. Pricing and participation may vary. Tax extra.
And now, the Inland News Update with Blake Trolley.
More evacuations due to the massive Thomas Fire. Mandatory evacuations continue due to the massive Thomas Fire in Ventura and Santa Barbara counties.
My brother woke up and he kind of just pretty much woke up the whole house and was like, our backyard's on fire. And so we just quickly threw whatever we could back to the trucks and we immediately left.
Carpinteria homeowner Alfredo Maya was forced to evacuate over the weekend when he woke up to find his neighbor's house on fire. He since has been allowed back in, but firefighters have told him that the flames from the Thomas Fire are headed back in his direction once more and he might have to leave. Hundreds of people in the Carpinteria and Mendocino area have been told to evacuate as the large-scale fire pushes their way. The Thomas Fire is now the 5th largest wildfire in state history, charring 230,000 acres. And this fire is triggering big changes for some local colleges and universities when it comes to their schedules. The mandatory evacuation zone for the fire now includes Westmont College in Santa Barbara County, sending students like Eric Foss scrambling.
I am unable to go back and get my clothes, and so I don't have some important things right now, but I have myself and my friends, and that's what's important.
Elsewhere, UC Santa Barbara officials announced yesterday that they would postpone the upcoming finals week until January 8th due to the fire. The winter quarter for UCSB will now begin on January 16th and will be shortened by 1 week. And anyone hoping that the air quality might go back to normal around Los Angeles County anytime soon, better think again. Mike Watts has more.
Air quality specialists in the region think the smoky air triggered by several fires is likely to hang around the region now that the Santa Ana winds have died down. Communities like Ojai are very polluted by bad air now, and officials are warning people with breathing issues to take precautions and limit their outdoor activity. Hospitals around Southern California have reported high numbers of patients with breathing problems over the past week. Mike Watts, NBC News Radio.
Your forecast today, 83 degrees in Riverside, cooling off to 49 degrees by tonight. With the Inland News Update, I'm Blake Trolley.
This is Dick from Carpet Masters. Carpet Masters has been serving the Inland Empire for over 60 years. We are locally owned and operated by the Stevens family. We not only clean carpet and furniture, we clean many loose rugs, including Oriental rugs. Oriental rugs are cleaned in our modern facility where the fringes are cleaned by hand, then hung in our modern facility to dry. We do not use steam cleaning to clean your fine furniture. Furniture is cleaned by hand using the same absorption cleaning used in the White House. Some furniture we bring into our plant to clean properly. We normally use 2 men on each cleaning job using the extraction method. There is nothing that would clean carpet better for our customers. Our job is to clean properly with quality first. Google Carpet Masters San Bernardino and give us a call, or go to carpetmasterssocal.com.
You're listening to... And now, it's For the People with Judge Herb Dodell.
Okay, good afternoon, ladies and gentlemen. Welcome to For the People. It's kind of becoming a custom. I just thought the same way. The reason it's called For the People is... You got something you want to say, Gary?
It's for the people.
That's it. It's for the people. And I'm going to tell a story here this afternoon to prove what the purpose of the show is.
Okay, cool.
And, the reality is we're doing our 6th show now. And I think it makes sense to kind of reiterate what the purpose of the show is. And it really is to help the people navigate through the system.
Well, I'll tell you one thing. I just want to let you know that you've done some remarkable work letting me know some of the facts that I had no idea about with the law. I mean, really amazing stuff.
It kept you from getting arrested.
Well, I don't know about that. But sued.
Not arrested.
Come
not necessarily.
on. Come on, Judge. I haven't been arrested in like 5 or 6 years.
I got to tell you, it's a horrible place to hang out in that jail.
It sucks.
It is the crowd, the social media, terrible place to be.
The food sucks.
The food is awful.
Oh, it's worse than the hospital.
Well, it's and it's overcrowded.
Oh, yeah.
You don't get to pick your roommates. And if you did, and you picked them, bad choice. That's why you're there.
Exactly.
Well, we're going to have a guest today, as a matter of fact. I'm very excited about that.
Cool.
We're going to have an expert on landlord-tenant, also known as unlawful detainer. For a number of years, I was assigned to that court, so I probably have heard a couple thousand unlawful detainer cases. And this guy has appeared before me a number of times. I always was impressed with his knowledge of the subject. It's a very complicated, somewhat technical subject, landlord-tenant. You get a 3-day notice. What do you do? Can you stall? How long? Can you stay there? What can you do? What if you file a lawsuit? So Brad Axelrod, who's an expert on the subject, is going to be our guest this afternoon, and he's going to answer the questions that I ask him. Of course, little softball questions, and any questions that you may think about.
I have some questions about that.
Well, that's good, because the point is we really want the public to understand what they're facing. And I've said this many times before. When you don't know what the outcome is going to be on any issue, and there's a question of uncertainty, you tend to be much more nervous and much more anxious because you don't know what's coming. But if you do know what's coming, at least reasonably expect what's coming, you can prepare accordingly. And if you can tune up your psyche, you can deal with it on a less emotional level and a more practical level, which gives you an opportunity to get some things resolved. I'm a big supporter of settlements.
Yeah.
I think you got to settle almost every case. You really do. The risk and the exposure. And I'm going to talk to you about a case because I've talked about what judges can do and what they do. That makes sense.
Well.
And that's what it is.
The voodoo that they do.
And that's what it is. I'm going to tell you how a judge had already decided what he was going to do and who was going to win. And you could see during the trial. The trial went on, I think, about 5 days. No jury. And this judge decided what he was going to do, and he just went out and created a way to do it.
He did it before. He already had basically...
the first day he'd said a couple of things which you start to say to yourself...
he already made his mind up before
absolutely.
Even the case went
There was no
down.
No question in my mind. Look, it was the guy with the 40 gallons of gasoline that I talked about last week.
That went poof?
The guy that went poof. No, that's a different case.
Oh, different.
That guy was an idiot. He poured all the gasoline, stood in the doorway, and lit a match. I mean, that was brilliance.
See, that was one thing I learned, that gasoline doesn't burn you. It's actually the fumes that actually burn you.
It's only the fumes,
right? I didn't know that.
That's what causes the explosion.
Thank you.
But the judge didn't like what the jury did. The jury went out and came back with a legitimate verdict, for whatever reason it was. Garcia, that's what it was.
Garcia,
my favorite juror. And the reality is that judges can do that. And I'm going to tell you a story about a judge who did exactly that because he wanted to.
Well, can you appeal somebody like that?
Yes.
I mean, you can appeal a case like that.
Yes, you can. But the reality of appeal is that, number one, it's expensive.
Right.
Number two, it takes time. Number three, a lot of times, 80% of the appeals end up in an affirmation, meaning they don't change things.
Right.
Only 20% get reversed. So, statistically, you're not looking at the best of records. And in reality, you have to have all this record. And a lot of times, lawyers don't make an objection or they don't raise something. And if you don't raise it in the trial, the rule is you can't raise it on appeal.
Oh, really?
There's a few exceptions, very few.
Okay.
But for the most part, if you don't say it, it's not part of the record.
It's
In
not
fact,
under appeals then. You can't appeal something that you didn't object to or bring out in court.
That's right. Or a decision that was made that you didn't object to or anything like that. The reality is that sometimes at the heat of battle, you don't think about it.
Yeah.
And next thing you know is the other side is raising, well, you didn't raise it before, so you can't raise it again.
And you can't raise it in an appeals court then.
That's generally that's the general rule.
Wow.
So one of the things I want to do is during the course of these shows is to talk about the general rule. There's going to be exceptions to just about everything. And that's why I don't give any advice. I make it very clear that anything I tell people who are listening to the show is not meant to be advice. Every case is different. Everybody has a different story, and
but you do give advice out. I mean, not advice, but someone wants to email you to ask you a question.
If it's a question dealing with proceedings and things of that nature,
you'll answer.
Happy to do that.
Okay.
Happy to do that.
And where do they go for that, Judge?
They go to askjudgeherb@gmail.com. Very good, Gary. You got this down to science.
Yeah, well, I've been in it for a minute.
Well, I must say I've learned a lot just sitting here listening to you before we go on the air.
Well, it's likewise. It's a mutual respect.
Well, here's the case, because I was just telling you before we started. I've been thinking about this case for a while now. It was a case involving one of these big credit reporting agencies. I'm not going to mention their name because I don't want to start anything and get into anything in detail, but this credit reporting agency allowed, I use the word allowed and advisedly, a hack. And as a result of that hack, many, many, many people's personal information was disclosed. Literally intended to be personal and private, got disclosed, including Social Security numbers, bank accounts, stuff you don't want anybody to know about.
Wow.
And it got out. And so one of the customers sued this credit reporting agency for damages. And I said to the plaintiff, all right, assuming that you can prove that they were negligent, because you have to establish something called liability, assuming you can do that, what economic damages did you suffer? And they said, well, we have no economic damages. I said, okay. What other damages did you suffer? Did anybody get information that shouldn't have had it, and as a result cost you something? No. I said, okay. Do you have any medical bills or anything like that to show how you were affected? No. End of the story. And the representative from the credit reporting agency was there. He was a typical guy with the crispy white shirt and the nice suit on, and very educated person. Not a lawyer, because you can't be a lawyer in small claims court.
Right.
And he basically said, they have no damages. And the answer is they were right. And so my ruling was for the credit card company, credit agency.
Boo, Judge, boo.
Well, let me tell you what the reason is.
Okay.
And I'll tell you why it's important.
All right.
The reason is in any lawsuit, whether it's small claims court or all the way up to the major cases, there are two elements generally. One is liability, meaning somebody did something wrong. In a contract case, it's a breach. In a tort case, tort is T-O-R-T, that's something like negligence, trespass, other kinds of actions. It's an entirely different set of rules. So that's the first part, is liability. The second part is damages. You have to show you suffered a real damage before you can recover from the other party. And we'll talk about that right after the break. This is For the People. I'm Judge Herb Dodell, and my book is called From the Trench to the Bench.
That's right. Get it. Amazon.com.
1050 AM, KCAA.
Herb Dodell is a lawyer and a judge for the people. Having served as a Superior Court judge, presiding over more than 9,000 cases, he has witnessed firsthand how complicated and corrupt the legal system can be. His goal is to show how things really work in the legal system so that people can navigate the legal system in the best way for them. Many people often feel marginalized by the legal system and are uninformed about how to proceed when unfortunate circumstances arise in their life. Judge Herb will pull back the curtain, lift the veil, so people can truly understand their rights, have access to top legal personnel that they can trust, and have knowledge about how things work so they can make better choices. Judge Herb isn't just knowledgeable. His integrity and spiritual values are truly what make him different. He cares about democratizing access and information for all and desires to turn on the light so the people, you, can benefit. For more information, email the judge at askjudgeherb@gmail.com. That's askjudgeherb@gmail.com.
Okay, welcome back to For the People. This is Judge Herb Dodell, and I'm now going to address why I made the decision that I made. Because there was no evidence of damages, everything was speculative. You can't have speculative damages. And since that plaintiff didn't prove any damages, they don't win. If that person had come in with a letter from a doctor saying that they couldn't sleep at night, they're so worried that people are going to be taking their credit, whatever it may have been, it would go to the weight to be given to it, but conceivably they had put on Medicaid. Whatever it is, if they had presented that and they met their burden of proof, which was to show that this credit reporting agency had acted below the standard of care and allowed it to happen, especially if they had notice of prior hackings and things of that nature, I would have found for the plaintiff.
Really?
I would have. But the purpose of my telling you the story is that when you're in court, you have to be prepared.
Yeah.
While you're not necessarily going to be a lawyer and necessarily know the technicalities of liability and damages, you can read up on it. What happens in small claims court? In fact, I put that a whole chapter in the book about that. That person was unprepared.
Yeah, yeah.
Now, there were also a couple of other considerations that I gave to myself. There may very well have been a class action.
What is a class? What, for people that don't know what a class action lawsuit is? What is it?
Okay, class action generally is you suffer damages, but your damages are relatively small and not sufficient enough to spend the money chasing after a defendant by yourself. In fact, if you see class actions against credit card companies or whatever, you get a notice in the mail that you're in the class. Yeah. You have a right to what they call opt-out.
Yeah, you know, I've actually got notices about class action lawsuits that I didn't even file for or anything like that.
You don't have to.
You don't have to. So how did they find you? This is sort of weird because, you know, I've gotten like $25 here or $80 there.
That's what you get, but the lawyer doesn't get that. No. Guess what the lawyer gets?
Billions.
Well, you know, it's a very lucrative field for lawyers.
I bet it is.
I even have a chapter in the book on class actions.
Yeah, okay.
The fact of the matter is that the lawyers find out who all the customers are or whatever it is, and they send them a notice.
Right.
That's when you get the notice in the mail.
Okay.
And it gives you an opportunity to what they call opt-out. Opt-out means you don't have to be part of the class if you don't want to be. But you better have enough damages to make it worthwhile for you to pursue the case on your own. Otherwise, you take advantage of the lawyers that are working for the class.
Yeah.
And they're doing all that work because they're going to get 40% of the outcome. So if they settle the case for $10 million, they made $4 million, and they split the rest among the thousands of other people that are out there. So you get a check for $4.07.
Yeah, exactly. That's exactly what's happened.
But the lawyers do good. Every now and again, you get a free upgrade for into business class. You know, if you're flying.
Yeah.
But
right.
Try to use it.
Yeah. Right. Yeah.
They never have any seats.
Yeah.
not for the free ones. So the purpose of my telling the story is, if this person had known enough to be prepared to prove, number one, liability and the ways to do that, you don't have to be sitting there, and there's certain inferences that could be done. and could show some damages, might have won. Big problem, potential problem, assuming no class action had been decided already, because that would have prohibited this person, if they were in the class, from bringing a separate action, unless they had opted out.
Right.
The reality is that this decision, even though it was in small claims court, is a factual finding made by a judicial officer.
So it could have like a precedent.
It could have been what's called res judicata or estoppel. There's a number of technical terms.
Which means what?
Means that they're bound and they're going to lose every other case because it's already been decided that they committed an act which caused them to be liable.
So even in small claims court, they could be bound?
Sure.
Wow.
It's a factual finding
Okay.
in a court.
Wow.
Now, keep in mind that a small claims court is the regular superior court. We're regular superior court judges, but the limitation or the jurisdiction is limited to certain amounts of money. Even though I mentioned it before, it's probably a good idea to mention it again. Individuals can sue for up to $10,000. Corporations, LLCs, are limited to $5,000. And if you file more than 2 small claims court cases for more than $2,500 in any one calendar year, you're limited to $2,500. So we see the collection agencies, and we see these lenders that come in. They're always suing for $2,500. They lend $2,600. They're suing for $2,500. They end up losing the interest unless they've gotten some of their payment made. But these are limitations.
Yeah.
And because they're limitations, we don't have as much time to give to each case, number one. And lay people, are not prepared to deal with concepts known as the burden of proof. Even though I always give a little speech. When I take the bench, I give the same speech every time. A little boring, but, it comes tripling off the tongue.
That's all good.
Bottom line is, most cases are decided on what's called the burden of proof.
Right.
The burden of proof in a civil case is what's called preponderance of the evidence, meaning more likely than not, 51% maybe.
Mm-hmm.
In certain courts, like restraining order courts, other than domestic violence, the burden of proof is clear and convincing evidence. That means it's more than just 51%, but it's not high enough to reach the standard of known as beyond a reasonable doubt to a moral certainty. That is the definition in all criminal cases.
Yeah.
So you still have a burden of proof in every civil case, and if the court says, I don't know, at the end, and remember, you got one judge sitting there and with a big calendar, it's a crapshoot.
Yeah.
Go out and settle that case.
Yeah.
They weren't interested. This credit reporting agency, I was told, this was the 6th case that had been filed against them. The mediator in our court told me that they've won all of them.
Oh, well, they weren't going to sell.
So I don't know if they were going to settle or not. I don't think they wanted to settle because it also sets a precedent for them.
Right.
And it's like a lot of people, even Trump, when he was running for president.
Who's that? Oh, the President Trump.
The guy, he didn't settle cases most of the time.
Never did.
He settled one recently.
But most of the time he'd try to just wait them out.
No, because he wanted everybody to know on the other side that they're going to have to go the whole 100 yards to get it, and they're going to spend a load of money, and maybe they'll get it, and maybe they don't. But you're going to face, in New York, a big Wall Street type law firm with thousands of lawyers, and your lawyer's got an office in Queens. It's a second floor walk up over the deli. I mean, you're not going far against the people with the money. In fact, when I wrote the book, I talked about the fact that the haves will almost always beat, I shouldn't say almost always, a lot of times, the haves are going to beat the have-nots.
How can the have-nots win then? They can.
I
say be prepared, right? Is that one of the ways the have-nots can be prepared?
This person, in the case with the credit reporting agency, if they had been prepared, they had a fighting shot. I probably would have gone that way, even though I know it would have ended up with an appeal because the defendants can appeal.
Right.
And somebody may not want to take on the giant like that and have a record from a small claims decision being used in San Francisco on a big case.
Yeah.
Because it's not limited to it's a finding of fact, as to the facts of that case.
Is that just in the state? Would that just be in the state of California, that fact finding,
No,
or would it be all over the country?
No, it might even be all over the country. It's a factual finding of liability.
Okay.
And the damages are limited to this one person's provable damages, and they may be different. Look, may very well have caused somebody to have their house foreclosed because somebody forged their name. It could be a lot of things.
Right. But this one case in small claims could set the precedent for all the other cases down the road.
Yeah, I don't know. I'm saying that as my opinion.
Right.
I don't know if there's any case law that says that, but looking at it logically, it's a court of general jurisdiction. It's a regular superior court. It's a finding. Both parties were present. An argument could probably be made or would be made that there were no attorneys involved, and they'd have to take the appeal up. And if they lost the appeal, if this credit reporting agency hadn't taken it up on appeal, or if let's say they did take it up on appeal and they lost the appeal, then there's no more appeals after that.
That's it.
That's in California.
Right.
That is it. You got one bite. Plaintiffs don't even have that second bite.
Yeah.
Because once you ask for this court to rule on a case, you're the plaintiff, you actually sign a document that says you understand that you have no right of appeal. What people have done when I've ruled in favor of the defendants and plaintiffs really want to appeal, they file a document with a request for reconsideration, kind of reconsideration. They discovered stuff afterwards that they didn't know before and whatever, and we have to rule on that. Mm-hmm. I don't remember, in fact, I can't remember any time that I ever changed my ruling based on a request for reconsideration.
Let me ask you a question. So what's the most important thing to bring to court? Is it just paperwork, or is it like what would you tell somebody like a have-not that's trying to sue somebody who's got big money and can bury him? What's the most important thing for those type of people, the underdog? I don't even like saying the have-nots, the underdog, to win a case or to be prepared for a case.
Well, the answer really is know your subject matter. If you're suing somebody on a contract, you need to know what the law is regarding breach of contract. You're going to be able to prove that they breached the contract. If you don't do that, you lose. You have to know also what elements of damages are considered. Are emotional damages available? Are punitive damages available? What is the amount that you get for a breach of contract? Can you force somebody to perform a contract? I once enforced a contract for a dentist on a dental malpractice case. I don't know if I mentioned it last week.
No, you have not.
Well, she lost all her teeth. And she came in and she wanted $10,000. The dentist was there and he was saying he didn't do anything wrong, whatever. I didn't have to be a genius to figure it out. Even though I'm not a dentist, I knew enough from what I heard and what I looked at to know that the guy was wrong. And I said to him, I'll tell you what, I'll give you two choices. Give her the 10 grand, take it out of your pocket or whatever, or fix it.
Or fix her teeth.
Fix it to her reasonable satisfaction. I'm going to give you 6 months to do it. And then I'll dismiss your case. Otherwise, you're going to have a dental malpractice judgment against you, and it's going to be a matter of public record. You don't really want to do that.
Right.
Do you? And she had lost about 80 pounds. I mean, she was horrible shape. She was standing in front of me. And I think I continued it for a couple of weeks, and I made some calls to some dentists. I wanted to be sure that I was on the right, that I wasn't going to put my foot in my mouth. I was reaching for that. I was definitely reaching for that. But the bottom line was...
What did he do?
The bottom line was he was going to fix her teeth.
Okay.
Look, at least she's going to have it done.
Yeah.
So you as a litigant really need to know what your rights are. That was another reason why I wrote the book, because I wrote it in layman's terms.
Yeah.
There are no legal terms that are not defined. So if this person had come in and was prepared, they might have won that case.
Okay, well, it's From the Trench to the Bench, Judge Herb Dodell. Get it on Amazon.com.
Right after the break, we're going to hear from Brad Axelrod.
NBC Talk Radio, 1050 AM, KCAA.
In his book, From the trench to the bench, Judge Herb Dodell demystifies the legal system, including both civil and criminal, the lawyers, the judges, and the process. As a judge, former deputy district attorney, and criminal defense attorney, knows the system. Side
Okay, we're back with From the Trench to the Bench with Judge Herb Dodell.
All right. Well, we have a guest today. As I think I mentioned when we first started the show today, he's appeared before me a number of times. I was always impressed with his knowledge and his familiarity with this a very complicated system. And I understand, having talked to him, that he represents both landlords and tenants. So I'm going to ask Brad some questions dealing with both so that the public gets a better idea of what they might be facing if they find themselves involved in a situation where they might lose their home. So are you there, Brad?
I am certainly here. How are you?
I'm great. Thanks very much. So let's talk about some possibilities. You know, somebody gets a 3-day notice to pay rent or quit. What does it mean when you say or quit?
The meaning of a pay rent or quit?
Yeah.
What the landlord is telling you that there's an outstanding sum of money due for the rent, and that if it's not paid within 3 days, he's going to move to bring what's called an unlawful detainer and what's commonly referred to as an eviction, to have you removed from the property. And it's important to remember.
Are there any defenses to that?
Of course there are defenses.
Well, what if you're the tenant and you just got one of those notices in the mail and you got rats running around your living room and you've been trying to get the landlord to fix it and get rid of it and he hasn't done it? What defenses does the tenant have?
The tenant has a number of defenses, and the first thing that everybody should know is if you're having problems with the property, if you're a tenant, you should document them in the form of emails rather than texts, because they're easier to retrieve, and a judge or will not look at your phone, or a jury will not look at your phone. You have to print texts out. That can be difficult to do, but emails are always a safe bet. You want to document the condition of the property. And the landlord, has probably been documenting the condition of the property also, but you need to show that you've made maintenance requests or that you've complained about problems that need to be fixed that are not being addressed.
That's called a habitability defense, right?
That's a habitability defense.
How long can you stall this? How long can you stall this? How long can you stall this out if you're the tenant?
Well, I don't say that you're stalling. I think if a tenant comes to me and they've got good defenses, you can stall it. You can delay it, certainly, to get appropriate justice. That means you can look at the complaint and look at the facts and see if you can file a document called a demur or a motion to strike because there's some problem with the complaint itself. If that doesn't work, the next thing you do is you immediately file an answer and you say, hey, we deny this, and by the way, these are the reasons why you're wrong and we're right. And those are called affirmative defenses.
Brad.
And hopefully yes.
Go ahead. I'm sorry. Go ahead. I didn't want to cut you. I just have a question for you.
Yes.
I actually, last year, I had cockroaches in my apartment, okay? It went on for like 2 months, okay? I mean, over and over, they brought the exterminator out. Finally, they fixed it. But then a month later, they raised my rent by like $200. Was there any defense I had for that, or do I just have to live with it?
Well, there are defenses. The first issue is you have a written lease that provides for the amount of money. They can't just raise it unless that lease is over. And if it's in a rent control jurisdiction, they can't raise it except by the amount that's allowed by the rent stabilization ordinance that particular year and any pass-through costs like registration, etc. Otherwise, if it's not under the rent control and absent any type of habitability or lease issue, they can raise the rent, as much as they want.
Even with the roaches. Even the roaches running around for 2 months, I had to deal with that. That was a total inconvenience to me. But I'm saying, the lease ended a month later, and then they raised my rent by $200, and I felt like, wow, they're sticking me. I mean, I had to go through 2 months of roaches, and then they raised my rent by $200 a month.
Well, the holy grail of a defense as a tenant is documentation. I would say to the tenant, if that's the case, you tell them that you're not paying the rent until the problem is taken care of, and you take the rent and you put it into a separate account at a bank. You put that in every month, just like you were paying the rent, but you don't give it to the landlord. You put it in that, basically it's an escrow account. The next thing you do is you call the Department of Housing. If you've got roaches, that kind of a problem, you call the health department to come out and take a look. You take pictures. You have witnesses that will be able to testify. And then the ultimate question that you always ask whenever you're a tenant is the unit you're in a legal unit? Because if it's not a legal unit, then all of a sudden it's a much different animal and the tenant is in the driver's seat.
You are talking about Carter versus Cohen?
We're talking about Carter versus Cohen. We're talking about illegal rental units, whether they're rent controlled or not.
What's the penalty for the landlord if it's an illegal unit, like you took a guest house?
The penalties can be severe. First, understand that if you rent an illegal unit, wherever you rent it, according to a case called Carter versus Cohen that came out in this appellate district, Los Angeles Appellate District, and you knew it was illegal, you have no fault, okay? If the landlord knew, he's got a lot of problems. But let's just say you rented an illegal unit, you didn't know, and the landlord didn't know. If it's a rent-controlled unit, you're going to be entitled to relocation fees, depending upon who you are and what your situation is. That there's a graduation in amounts that go up depending upon your circumstances. You're going to be entitled to all the rent that you've ever paid back.
Ever?
You also, ever, going back 4 years.
Wow.
Okay? All the rent that you've paid, that's what the case says. He's collected illegal rent. If the landlord knew it was illegal when he rented to you, he is liable for 3 times the amount of rent in the rent control jurisdiction.
Wow.
For 1 year.
Plus the legal fees, and that's just for 1 year, the treble amount. But it still can be a significant amount of money if you're paying $1,200, $1,500, a month. That's a lot of money, times 3. So, and these are in either the municipal code or by statute or by the ruling in this case. You also have claims for, depending upon if you knew or not, fraud, intentional misrepresentation, negligence, okay, violation of the fair business practice, the California Business and Professions Code for unfair business practices. And if you advertised it and you've kept that ad, you may have a liability for unfair business practices for false advertising. So it opens up a panacea of problems for the landlord if the unit is illegal.
That's like when you say illegal, it's like taking the garage and converting it into a residence of some kind. Is that what you're talking about, with doing it without a permit?
Yeah, you're basically talking what some people refer to as a granny flat or a mother-in-law apartment. It could be a space over a garage. It could be a rec room. It could have been a laundry room that got converted. A lot of the times they're pool houses or garages, and what's happened is somebody's come in without permits and they've turned it into an apartment. And you can't do that. You have to get the permits from the city. Has to be inspected. Has to be inspected during the entire process that it's undergoing wiring, plumbing, all those changes. Just like if you were building a house, and it won't have a certificate of occupancy. What's interesting though is, even if it's not in a rent-controlled area in Los Angeles, so there is no rent control where that granny flat is, where that converted apartment or room is, it comes within the rent control statute. So you are liable for everything that you would be liable for under the rent control statute, and the landlord will still have to pay the tenant relocation fees. Excuse me.
Let me ask you a question. As far as like rent control in Los Angeles or in the Inland Empire, I mean, there's pockets of it, or was it a city ordinance or county? How's that all roll out?
Well, it's the it's a Los Angeles municipal ordinance. It's part of the municipal code for the city of Los Angeles. But of course, Los Angeles encompasses a lot of places like North Hollywood, Sun Valley.
I live in Woodland Hills.
There's Woodland Hills.
Yeah.
I believe it would be covered.
Really? Okay.
Also, you have a separate rent control statute for West Hollywood, which also covers parts of Beverly Hills, and you have the Santa Monica rent control statute.
Yeah.
Up north, of course, you have the one in San Francisco, which is kind of the model for everything. So, but you have pockets, remember, in Los Angeles that are county and not part of the city. And so rent control would not apply. And a good example of that is San Pedro, where part of San Pedro is covered by rent control and part of it is county.
Wow, it's interesting.
Have you heard the term cash for keys?
Yes.
Tell us what cash for keys means.
What's that, Judge?
I've ruled on cases like that.
Cash for keys is, well, as a landlord, you might determine that the tenant, where you bought a house that had an addition on it, you rented it because, hey, I'm buying a house and it has the added advantage of being able to produce income for me because it's got a rental unit on it, and then you come to find out after you bought it, which is a whole nother, legal can of worms, but you found out after you bought it and you've rented it to somebody or there's a tenant in there already, that it's an illegal unit. Well, before it gets to be a disaster in court, you can go up and say, look, I need the unit back. I'd like to, work something out with you so that you can find a place to live and, have the ability to cover the move first and last month and stuff, and make your own arrangement. But you have to remember that under the rent control statute, there's now basically a cash for keys municipal code section that gives the tenant the right to revoke it or to repeal his acceptance of it for a certain amount of time afterwards. It can also be used by a landlord who's got somebody in a condominium, that wants to pay them to leave. That it could be under rent control or not under rent control.
So basically, they're paying off the tenant to get out.
Basically, yes. Cash for keys is exactly what it implies. You make sure you have a very strong written agreement, whether you're the tenant or the landlord, saying exactly what's going to happen, exactly what each party has to do in order for the money to pass. The tenant has to do A, B, C, and D, and he has to do it exactly the way it's set forth in the agreement. And the tenant is telling the landlord, well, you've got to do, E, F, G, in response to my doing exactly what I'm supposed to do in the agreement. And everybody waives any further claims they have one another down the road.
So the tenants can prevail if they have the right facts to support legitimate defenses or otherwise. They can prevail.
I'm sorry, I couldn't quite hear the question.
So the tenants can prevail if they got facts on their sides. It's not
many times, and even if you don't think that you might prevail, the tenant may have sufficient leverage. Remember, what the landlord ultimately wants is he wants the keys back. He wants that unit back. He doesn't want to spend a lot of money to have to do it. If you really don't have the money and there's nothing to get, the best thing to do is to strike a deal with the landlord, and you make an arrangement where you reduce the amount of money you owe or they waive the amount of money you owe. But the important thing you get out of the bargain is that they seal the record. And that's a negotiation, and many times that does not happen.
I've told that to many.
Walk into court on the day of trial.
I've said that to many people when I try to settle cases. I tell them, you know what? I'll seal the record which protects you if you settle. If you don't, good luck to you. Okay, so Thanks very much, Brad. He can be reached through me calling or getting in touch, askjudgeherb@gmail.com. And I'll give you the contact information if you need a specialist in landlord-tenant Brad Axelrod. Thanks very much, Brad, for coming on the show today.
Thank you. You have a wonderful week, and my best to you and all your staff.
Thanks.
1050 AM, KCAA.
In his book, From the Trench to the Bench, Judge Herb Dodell demystifies the legal system, including both civil and criminal, the lawyers, the judges, and the process. As a judge, former deputy district attorney, and criminal defense attorney, he knows the legal system. He has the inside information that you need to pick a lawyer, and he's here to give it to you. No matter what you're facing that makes you think you may need a lawyer, Judge Herb will shed valuable light on your situation and reveal your best options and many secrets of how the judicial system actually works. To find out more about how the legal system really works, you can get your copy of Judge Herb Dodell's eye-opening book, From the Trench to the Bench, at Amazon.com.
Okay, welcome back. This is For the People. I'm Judge Herb Dodell. I said when we first started the show I was going to talk about a case where a judge decided he wanted to do whatever he wanted to do, and he did it. I think we even said doo-doo.
The voodoo
Yes,
that
did.
he do-do.
We did. True story, because as I mentioned when we first started, if you know what to expect, or if you can think about what you can expect, and recognize that judges are going to do whatever they want to do whenever they want to do it, some better than others, some not so good, then you're better prepared. So here's what happened. Guy has a business, and he has a partner. In his partner, they're in the recording business, and they have all kinds of equipment, and they take an inventory when they start the business together. They're partners. They're not great bookkeepers, but they have records. And they bought a lot of equipment. One of the partners had another studio, which was very, very successful, world-class, and had a lot of valuable equipment up there. But a lot of it was in the second studio, for which they were going to be partners. They were partners. And then there was a flood. It's an old story about how do you start a flood, but there was a flood, and some of the stuff was damaged. They took an inventory of it, and then he decided to close the studio, and they had all this equipment together, but they didn't take an inventory, a real inventory of what it was, but they had an inventory of what was damaged in the water damage part of it. And so the one partner said to the others, look, let me store it up here in my other place, and then when I sell it down the road, we'll split it. And we're talking serious money. We're gonna split it. So the other partner, being much more low key and laid back, said, "Yeah, that sounds right to me. You know what you're doing, and at some point you'll sell it, and I'll get my half."
You trusted him.
Yeah, he absolutely trusted him.
Okay.
And many, many years passed, and none of the stuff was sold as far as he knew, and so he didn't get his half. And the other guy gets sick and passes on. They find out that years earlier, he had sold hundreds, almost $1 million worth of equipment to some other company. And
didn't tell him.
Didn't tell him.
Wow.
He finds out after the guy's dead that the stuff is not there anymore. It was sold, and he didn't get his share.
Oh.
And so he sues to get his half share. He sues for an accounting. In other words, I want to know. That's a legal term, meaning I want to know what you did with the stuff that belonged to me. And they had a written contract that they were going to split it. And the judge, from the first day when the partner, the good guy, testified, because the other guy was gone, for whatever reason, he didn't like him.
Really, just that vibe.
Just didn't like him.
Just didn't like him.
He became adversarial, kind of. And you're sitting there and you hear what this is coming out, right? Now, all you need to do is prove it was there. We had witnesses that showed that the stuff was really all there at one time. It had been moved. It had been sold. There was invoices showing what it was sold for.
You had records of it.
Yeah, it was a $900,000 payout.
Wow.
And he didn't get a dime. And so the judge is just kind of cross-examining the good guy, like for whatever reason, because many years had gone by. And so
what was he asking him? Like, why didn't you ask earlier, or why didn't you keep track of
well,
it?
He says, I trusted him. I trusted him. He was my buddy. You know, he had a great studio. He was doing good stuff, and I had no reason to disbelieve him. He was an expert in what he was doing. And now, of course, the wife is resisting because she didn't want to give up half.
Of course.
And so she testified, believe it or not, that she received $900,000. She testified to it. And in closing argument, I said, well, you know, she got $900,000. He says, no, she didn't. She got a lot less. She made a mistake. I said, he's the judge. He shouldn't be correcting her.
The judge is
correcting her.
Oh my God!
And then
what did you do?
And then he sat quietly and professionally. So
because you have to.
So he said, well, you know, where's? He says, I don't see any final inventory. Well, you got an inventory of what was sold. I mean, here all stuff is got ID numbers on it and everything. So he comes up with this idea that, well, you know, some of the stuff had been damaged in the water and needed to be repaired. But there was no evidence of any of that at all. And it had all been sold and the numbers were all there. And he says, well, you know, if he had to repair all of this stuff, it had no value anymore. So he gave the good guy $0.
Oh, my God.
Now, all the stuff is there. Witnesses, eyewitnesses.
Invoices.
Everything.
Everything.
He decided he wasn't going to give this good guy anything. And he proceeded to do exactly that. He was making it up as he was going. And he'd have us come back, and then we briefed it, and we did spreadsheets, and we did inventories, and we did everything else. And he refused to acknowledge even the inventories that had been taken by the both of them before the water damage, to the extent there was water damage. And even there, we had mechanical engineers, we had recording engineers come in and said this was the top of the line stuff.
Well, it's $1 million. That's top of the line stuff.
It was more than $1 million. Actually, they only sold $1,900,000.
Right.
900 of it. There was still a lot left. Still some of it still left.
Wow.
And he was just he shouldn't be on the bench anymore, this guy.
Is he still on the bench?
Oh, he certainly is.
He is.
He is.
What?
And I tell people, if anybody
Where?
has a, well, I'm not going to mention his name.
Come on. You don't have to mention his name. What city? Los Angeles?
Downtown.
Okay, he's downtown. Superior Court.
There's only 500 judges down there. So go find him. But I've said to people say to me, do you know this particular judge? And I say, yeah, I know who he is. And the only way you can prevent having a guy like that is to know in advance that that's what you're looking at.
Can't you file something against him?
Yes, you can. You can file only before the case starts.
Oh, you can't do it afterwards?
No.
So after the case happened, you can't say, hey, this guy was biased?
No, once he makes a decision, one decision, you can't get rid of him or her. They're there for the rest of the time. You can appeal on the grounds that, and it's called abuse of discretion.
Yeah, bias.
And bias is also a part of abuse of discretion. And you could show that he or she ignored evidence, but you got an appeal. You're looking at 1 year to 2 years. You got to buy the record. You got to buy the transcripts of all the proceedings, and you have to pay an appellate lawyer to do it. So a lot of these judges, colleagues, male and female together, by the way, it's not limited to any particular group.
Right.
They just do whatever they want.
I mean, how can they get away with that, Judge? I mean,
they do.
And there's nothing anybody can do about it.
No, every now and again you get. I've had, I think, in my 9+ years, I think I had 4 complaints. I think over that period of time, disgruntled litigants who lost and were looking to make some noise over it, and I had to write a response. I actually really had to write a response.
I bet.
Sometimes I had to listen. We tape record all of the proceedings.
Right.
Some courts we have a court reporter, some we don't. Small claims court, we don't have a regular reporter. It's all tape recorded.
Right.
And so you listen to the tape, you say, what the hell are they complaining about? Just disgruntled.
Right. But what did you do about this one? This is $1 million.
It's on appeal.
It's on appeal still?
On appeal.
Is it? How long has it been? How long has it been? It's just recent that this went down.
Yeah.
Really?
Yeah.
And so you appealed it. And
appealed.
Okay, it's being appealed, and now this judge is going to hear it again.
Oh no. That's
Okay.
heard. It's heard by a panel of 3 judges.
Oh, okay, that's what I'm asking. So that's what I asked. Okay, he's done. He's done.
He's done, mainly done.
Right.
If it's reversed, believe it or not, you could get sent back to the same guy.
Oh my God.
In fact, I had that happen one time, but I pitched the judge. I said, "You don't want to hear this again." You're right, I don't. And so we ended up. That's the case that went to the Supreme Court, by the way.
Wow.
That judge was a decent guy. So you know what? You're right. I did it once. I'm not going to do it.
I'm done. Do you think this guy, if it's appealed and you win the appeal, do you think it gets sent back to him? Do you think he'll hear it again?
No.
You don't think so?
Nah, he was lazy to begin with.
Really? You don't think he wants to deal with it?
He kept moaning about how he had 500 cases, his active cases, and he didn't want to spend the time. He was a horrible.
He is, you mean?
He is. He is.
Oh, come on, give us his initials.
Nah. Oh, I'm so tempted.
Oh, I know you are.
You have no idea.
I know you. That's why I'm trying to bring it out of you.
But every now and again you get a really good judge too.
Right.
Some of them have been very, very good.
Most judges are good. They're pretty honest and forthright, right?
Yeah. Well, there's a judge. One of my favorite judges is Judge Terry Green.
Okay.
I run into him in the courthouse every now and again. He was a legitimate guy. Everything he thought about, he did because it was the right thing to do.
Cool.
And that happens more often than not.
Yeah.
The bad ones are a very small minority.
But man, if you get a bad judge, it's game over. It's a bummer.
Could be.
It is.
Could be.
It is.
If they're making their mind up before the case starts,
oh my God.
Where are you going? You're swimming upstream.
Yeah. I mean, that's crazy.
But this is the system, and we talked about how judges get appointed as opposed to getting anointed.
Yeah.
And you got who's sitting there.
Wow.
Some of them are there for the absolute wrong reason.
That's sad.
Absolute wrong reason. I mean, I could tell you stories without telling you the names of the people.
You are telling a story.
I'm telling you. But the truth of the matter is, some of them are better than others.
Yeah. Yeah.
And some stay in. Now the real trend is they get an appointment, they stay like 3 years. Instead of staying for the 20 for the pension, they stay for like 3 years and they join one of these companies, what they call dispute resolution companies. And some of them are getting $800, $900, $1,000 an hour. And they're retired judges and they act as mediators. Some of them are very, very good.
Right.
And others are acting as arbitrators, and you get paid like you're the judge and hearing an arbitration. So better than sitting listening to traffic cases from 9 to 5 and putting up with all of the bureaucracy.
And not getting paid that great.
They don't get paid so bad.
But I'm talking about the arbitrators and mediators are getting paid a lot more than the regular judges.
Yeah, and they can pick their own schedules.
Exactly.
If they want to take a 3-week trip, they go. Not available. You can't do that when you're on the regular bench because you have
a calendar.
You have 6 weeks a year vacation.
Right.
That's what you got. In fact, one of my very close friends, who's responsible for my even getting appointed, he takes 6 weeks off every year and he goes to Lebanon, where he comes from originally.
That's cool.
And that's his vacation every year, 6 weeks off to Lebanon. And many judges would rather be able to take vacations whenever they wanted and not be limited to a particular period of time. So you take the job, you take the what goes along with it. Management is no different than management in any business. The presiding judge, or what they call the site judge, decides where you're going to be and when you're going to be. They don't want you over here. They send you to Antelope Valley.
Oh man, you don't want to go there. All right.
I did go there, as a matter of fact. I sat in Antelope Valley more times than I really liked it. I told you the story about the presiding judge walks around with a gun.
Yeah.
Strapped to his belt. I said, "What wearing a gun for?" He said, "Hey, we're in Lancaster.
Hey, it's a Wild West out here."
In fact, we didn't even go off the property for lunch.
I hear. Hey, the show is gone.
Show's over.
It's over. Hey.
Okay, next week.
Next week.
Anyway, any questions? Ask Judge.
KCAA Loma Linda, 1050 AM, 106.5 FM, and now 102.3 FM.
I'm Tom Busby, CNBC. Soon you'll be able to watch almost any NFL game, even February Super Bowl, online or on your phone, no matter who your carrier is. That's after Verizon extended a deal it has with the league